They probably have to send Ryan Reynolds in to testify, and they are shaking in their boots. Yes, I'm talking about Vanzan, Van Sham, Van Scam of a company. They're finally back on the docket, so y'all can stop asking me about it. I finally have answers for you. Let's get into it. Hello there, beautiful people, and welcome back to another episode of Around and Find Out. I'm still your host, Elsie. I have not changed yet. I appreciate you for being here. I want to thank you guys for your continued support. But today we got a good one. We caught a live one, people. I am filming this at 3:14 a.m. Mostly because I was on live with everybody and all the attorneys over on TikTok, and we took forever before we got off live. So I'm finally getting around to film this now. And guys, let me tell you, this one is good. And it's starting to look like Vanzan might be unraveling right in front of us because they are running scared, like little church mice. Let me tell you what happened. While y'all were asleep, or depending on what time you go to sleep, or if you're awake, you saw on the docket that Kevin Fritz has filed a motion to compel our friends Vanzan to spill the beans and speak up because it's about time. Yeah, it's about time we do that deposition. But who are they going to send for the deposition? Oops. I think I'm getting ahead of myself. Let's actually read what Kevin Fritz said and let me break it down. Let's get jiggy with it. Our friend Kevin Fritz, whom it feels like we haven't heard from in a long time, hit the docket, and he says, Dear Judge Lyman, in connection with the deposition set for September 30th, defendants Jen Abel, Melissa Nathan, Justin Baldoni, We're First Studios, everybody and their mama over there, move pursuant to federal rules, blah, 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 for an order compelling non-party who Vanzan, Van Sham, Van Scan, Inc., to designate a witness prepared to testify about the full period of its relationship with plaintiff Stephanie Jones and Jones Works. As set forth herein, Vanzan is attempting to curtail its testimony to omit information the court has already declared is relevant. Now, in plain English, again, I'm going to tell y'all like this. If you don't know who Vanzan is, what Vanzan means, you are in the wrong place. I am not going back for a whole history lesson. Here's what I can do for you. In a few quick sentences, Vanzan is a company that Blake and Ryan own that can't nobody confirm if it's a real company or not. But that's the company that Blake and her people thought they were quick enough to use to get a subpoena to obtain Jen Abel's text messages, phone records, all that stuff to pretty much use as a basis for their lawsuit. In plain English, without Vanzan, we're not here. Without Vanzan, Blake has no legs. But still with Vanzan, Blake has no legs because she didn't use Vanzan the right way. If that doesn't make sense to you, I know. You should have been here for class when we had this lesson back in, what month was that? March? February, April, I don't know. I've lost track. Ask the people in the class to show you their notes if you're confused about what Vanzan is, because teacher does not have time to go through the entire thing. But I'm sure you can keep up while I teach. So we've always known that Vanzan was not a legitimate company, right? Allegedly. As my friend Lauren from Court of Random Opinion likes to say, Vanzan is a broom closet and they need to reach in there and get whatever the waiver parties are asking for. Well, the time has come. Waiver parties are now actually on the docket asking for Vanzan to produce witnesses, employees, somebody to step in and speak on behalf of Vanzan. Not just your lawyers typing up a little letter to the judge. We need actual bodies on bodies to speak on behalf of Vanzan and explain what the hell your company is, what they were doing, the entire time, how they even came about this lawsuit that led into a subpoena, blah, blah, blah. And Vanzan is looking around their broom closet and they're realizing there is not a soul to send because it's not a real company, allegedly. You didn't hear it from me. Even though this is recorded, you still didn't hear from me. Rule 26 provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense proportional to the needs of this case, considering, amongst other things, the party's relative access to relevant information. The importance of discovery is resolving the issue and whether the burden or expense of the proposed discovery outweighs its likely benefit. The Vanzan people are also trying to, we don't even know if there are people there. I don't know why I'm out here giving them props. Vanzan and its lawyers are trying to say there's a little burden here. There's no burden. Absolutely no burden. Vanzan is quite literally doing the little Kim dance with the Wayfair parties. And they're ducking and shucking and jiving, just like, ooh, now you see me, now you don't see me. Somebody's gonna have to tell Vanzan to pony up. We need an employee. We need your CEO, your manager, your COO, your CFO, somebody, anybody that can speak on behalf of the company. And Vanzan doesn't want to do that. They're wasting your time, the court's time, my son's time, everybody's time by saying this is a burden to them. They don't have any relevant information, even though the judge has already decided they do, in fact, have relevant information. Ms. Abel's counterclaims allege that in August 2024, just prior to her scheduled departure from Jones Works, we know now, again, the people who were not in class, just when Jen Abel was about to leave Jones Works, right? It was a little tiff over there. Jones Works was like, sign here, sign here. Some scary man came and took her phone. If you weren't here for that lesson, again, it's hard to catch you up while I try to catch other people up on this. If you don't make it to class, remember to take your notes from your classmates. The Jones party seized her cellular phone, accessed her contacts, and downloaded them. We also found out later, right up until January, that they still had access to her iCloud. Scary times, scary times. The counterclaims further allege that Stephanie Jones disclosed at least some of Ms. Abel's private communications to the Lively parties no later than August 21st, 2024. Jen Abel's boss, who was supposed to be Justin Baldoni's publicist, was literally working in cahoots with Blake Lively and her people. Like, we covered that. Everybody knows that by now, right? Okay. They continued to access Ms. Abel's private text messages thereafter, and at some point transmitted Ms. Abel's stolen communications to Ms. Lively, her husband, Ryan Reynolds, and Leslie Sloan, Ms. Lively's publicist, to harm Ms. Abel. And Justin, to be honest. Ms. Abel also alleges that Ms. Lively conspired with the Jones parties to obtain Ms. Abel's stolen data under the guise of legal process. Again, legal process. They pretended to be Vanzan. Vanzan is suing Jane Doe's, John Doe's, a bunch of Doe's. Doe, a deer, a female, a deer. Exactly. And they got a fake sham subpoena, waved it in their face, and was like, yeah, we need to see these phone records. Only after they had actually seen the real phone records and knew they were going to use things in Jen Abel's phone, but because they stole it, now they needed protection, right? They needed to CYA. What a CYA means, cover your ass. Okay. On September 27, 2024, Ms. Lively used her company Vanzan to file a lawsuit in the New York State Supreme Court against Doe defendants. I just explained all that. The complaint in the Vanzan lawsuit alleges that Doe defendants, the identities of whom are unknown to Vanzan, breached unspecified obligations, even though Jen Abel, Stephanie Jones herself, who stole the text messages for Blake Lively and her people, Justin Baldoni, nobody on the Wayfair side knew what the hell a Vanzan was. Matter of fact, none of us knew what a Vanzan, Vansham, Vanscam of a company was until after the fact, when we figured it out. The complaint in the Vanzan lawsuit alleges that the Doe defendants, the identities of whom are unknown to Vanzan, breach unspecified obligations via unspecified oral promises and unspecified written agreements. Where? Days after the Vanzan lawsuit was commenced, Vanzan issued a subpoena therein to the Jones parties, demanding the production of documents pertaining to the film It Ends With Us, Ms. Lively, Mr. Reynolds, and sexual harassment and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed by Vanzan in the Vanzan lawsuit. The Jones parties then handed over Ms. Abel's communications to Vanzan. Subsequently, the Vanzan lawsuit was discontinued in December 2024. What exactly happened in December 2024, you remember? Blake got the New York Times to act a fool. Blake got her CRD complaint. Blake got her lawsuit on the docket, and everything quite literally broke loose. A reasonable person can come to the conclusion that as soon as Blake got what she wanted and she got the lawsuit to hit the docket, she let go of the subpoena that she swore she needed for Vanzan. And that is what we call a sham subpoena, a sham lawsuit, right? The same month, Ms. Lively included those communications in her pleadings. I just told you that. In late June 2025, Ms. Abel filed a motion to compel Vanzan to produce certain documents in a response to the subpoena. In a memorandum and order dated July 7, 2025, the court properly determined that communications between Vanzan and its counsel and the Jones parties and or their counsel concerning Vanzan lawsuit are relevant, important. You can use it. Specifically, the court noted that the statutes under which Ms. Abel brings her claims prohibit both obtaining and disclosing protected information. Remember, we talked about how, like, at this point, is borderline. She gave it up because she thought like this was a legit subpoena. Also, she had no idea they had already seen what they needed to see, and the subpoena was just a cover up. The Wayfair party's deposition subpoena commands Vanzan to produce a witness who can testify about enumerated topics. The topics including the ownership and management of Vanzan, Vanzan's communication with Jones parties, the subpoena issued in the Vanzan lawsuit communications with Lively related to the subpoena, and Vanzan's search for relevant documents. To the extent that topics number 4 and 5 could be construed as overly broad, the Wayfair parties have agreed to narrow topic number 4 just to John Abel's counterclaims in this action, and the defenses thereto narrow the topic number 5, Blake Lively's allegation in paragraph 10 of her second amended complaint that she obtained the communication cited in her pleadings in connection with a lawful subpoena. Saying you got it through a lawful subpoena doesn't mean you saw it, then use a subpoena to cover your ass. Now you're saying it's a lawful subpoena. Nobody has seen the subpoena, like a legit one anyway. So now the Wayfair parties are asking Vanzan to show their face. Because right now we're speculating, right? We've seen the documents, but we still don't know the face behind Vanzan. We can't even confirm that Vanzan is a legitimate company, let alone that has a legitimate CEO whose name is not Lively or Reynolds. Nonetheless, Vanzan is refusing to provide a witness who can testify at a deposition about such communications and related topics. Next to the subpoena, Vanzan will only provide information for each of the topics starting from on or about the filing date of Vanzan lawsuit, which is September 27th, 2024. So Vanzan is only offering to talk about everything that happened after the lawsuit. No, that's not what we're asking you. We want to know how the lawsuit even came about, why you thought you could sue these people. What did your company even, what did your company do? We want somebody who can answer those questions. How did you come up with a decision to even sue my client? We want somebody we need somebody who can answer those questions. We don't just need answers for after the lawsuit became public and everybody found out about your scam of a company. Vanzan stated that it would designate a witness reasonably prepared to testify about non-privileged information responses about what happened after the Vanzan lawsuit was commenced, but not before it was filed, even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of John Abel's electronic data seized by Jones parties are subsequently delivered to Blake Lively is highly relevant, and the judge considers it very highly relevant as well. One of Vanzan's very, very stupid arguments is that the information you're seeking from us can be obtained from other sources, so go get it from there. However, as the court stated in its memorandum and order, there is no per se rule that party sources must be exhausted before documents are subpoenaed from third parties. The court doesn't give a shit where I get it from. You can give it to me, somebody else can give it to me, but the court is not forcing me to go get it from somewhere else before I come knock on your door. Therefore, I need you, Vanzan. Stand up. Will the real Vanzan please stand up? With all that said, the Wayfair parties respectfully request that the court issue an order compelling Vanzan to designate a witness, Ryan Reynolds, because who else are you going to designate? You guys also remember Blake Lively's lawyers had that mishap on the docket where they were trying to say Vanzan, but they used Blake's name interchangeably. So they messed up there, right? Like, at least you've now let me know you guys are connected. So somebody has to step up to the plate. And I think it's going to be Ryan Reynolds, because if not him, who? In brief, what am I saying? Vanzan is trying to hide behind technicalities. They're trying to hide behind a timeline that doesn't serve them. They know whatever they say can and will be used against them in a court of law. They also know there is definitely a relationship between them, Stephanie Jones, Leslie Sloan, all of them, they're intertwined. That doesn't help Blake. That doesn't look good for Blake. So if I was them, I would do the exact same thing and run away from my problems. And filing a bogus lawsuit to get a bogus subpoena, to get somebody's real life text messages and stuff to use for a lawsuit, borderline crazy. Borderline crazy. And the Wayfair parties have every right to ask what they're asking. Let me know if that made sense to you. It didn't make sense to you. What you think about it? Do you think Vanzan needs to pony up a person, specifically Ryan Reynolds or Blake Lively? One of them has to, or at least one of Blake Lively's 16 personalities. Somebody has to step up to the plate and be a man or a woman and answer these goddamn questions, because we got a lot of them and somebody's going to answer them come hell or high water. And I hope to God this is pissing the judge off, because he had already ruled on this. And now the Wayfair parties have to come back and beg because Blake and Ryan think they're above the law once again. Well, with that said, I'm going to leave you. I'm going to bed. Please make sure to like, share, subscribe, leave a comment. Let me know what you think about everything that's going on. And I'll see you on the next one. Have yourselves a great day. Bye bye.